So this is a pretty boring headline talking about your raise, but the way you can focus on this is a couple different angles. If you're an issuer, it can help you with deciding what you can and can't say. It's going to talk about some hot topics such as community channels. So one popular one is Telegram, for example. But if you're on the investor side, it can give you some hints at a lot of startups are getting smart about talking about they're doing a Reg D raise. We'll also talk about Reg A plus and CF briefly, but a Reg D raise to do their STOs. And with that, there are restrictions on what can be said or who's responsible for what is said, and you can get a hint at whether the token offering is really following a Reg D or not. These points that I'm going to bring up are not getcha, trap you points, so they're pretty big, pretty high level on the rules, meaning that if the STO is not following them, then they might, it's a pretty big indicator that they might not be following the Reg D requirements necessary to comply with an STO, or to do an STO. Oops. There we go. Okay. So the types of raises. There are a number of types of regulated raises. We're just going to cover Reg D, 506B, and C. So
Can I back you up just a tiny bit? Do you want to just, for anyone that doesn't know where Reg D is, do you want to just click?
Yeah, well, so a Reg D is a private offering, and we'll get into that in just a second here. We're going to go over a B and a C. Reg B, so that one, it allows, people like it because they hear it allows non-accredited investors. Accredited investors have certain thresholds you have to hit, meaning either a certain net worth or a certain amount of revenue coming in. So people believe they want the non-accredited investors because it allows you to have a wider pool of people. However, even then, a Reg B limits the number of non-accredited investors you can have. And it also puts a lot more restrictions on what you're allowed to say during the raise. Reg 506C also allows you to, is only for accredited investors, but it allows you more freedom on how you can promote your raise. These are still considered private offerings, and we'll get into what creates the private offering. Reg A plus, that is what some people call a mini IPO. So you're going to file, all of these you file forms with the SEC, however, it's just the amount of requirements there. The Reg A plus, we're going to talk more about we're going to talk about the marketing side of it, specifically before you file with the SEC. And then Reg CF is the crowdfunding regulation. That one you're allowed to, we're not really going to focus on it too much because it's not very popular. Success-wise, it's not as popular. You can talk about your raise, that you're doing a raise, but you have to point the customers or the potential investors to the portal that has the details of the raise. So for that reason, you can say what you want, but not about the details. Just send them to the portal. So that one's simple. We won't go any further with that. So these are called private raises, the Reg D raises, not the Reg A. And that is because you can't do general solicitation. And the SEC doesn't have an exhaustive list, but they give you an idea of what general solicitation is. They talk about advertising, talk about promotions of the raise through articles, in magazines and websites. So the original conversation was articles and magazines, publications, that side, but obviously they had to update when the internet came about, websites came about, and they include social media in these conversations. They have a lot of letters out there, no action letters and such, that allow you to determine what can and cannot be said. The final one is tombstone advertisements. That's a little more, it's like a one-off situation, but that's where you're announcing the success of a previous raise with the idea of exciting and soliciting investors for the next raise. That's considered general solicitation. You're not going to be allowed to do any of these with a Reg D raise. So that's what's not a Reg D raise, but we can also talk, or what is considered general solicitation, this is what's not considered general solicitation. Again, this is not exhaustive, but this is just what we know. what the SEC has pointed out. These are Form D notices. That's what you actually file with your Reg D raise. Those will become searchable for the public, so they don't consider that general solicitation, even though it's out there in the open. Any sort of information you give about the raise that's outside the U.S., whether it's a presentation that you give or actual printed material, for those, you can bring them back into the U.S. And give them to journalists, but you can't abuse that power. So don't take everything you want to share, start out outside the U.S. and then bring it back in. That's the trap. Then that's abuse, and it's not going to fly. And then publications from Rule 135C, that is very nuanced. So we won't get into that, but you would just talk to your attorney about how you can do that. And that's talking with foreign investors and how that relates. This is talking to foreign investors as it relates to Reg D, not Reg S, which is a very popular form of talking to international investors. There are a lot of no action letters out there. These are very facts and circumstances specific. So while you can look at different no action letters and feel you fall into that no action letter, and that you're allowed to do whatever communication you want, you have to take it very specifically. Any changes to those facts could knock you out of the letter. So it's good to get a second opinion on how those will apply. Then we have the question of what is a private offering. So it's a private offering when you're talking about what communications are allowed in a private offering. You're looking at the investors and you want to make sure you have a substantive and a pre-existing relationship. We'll talk about the total number of investors and sophistication of an investor as well. But the substantive and pre-existing is what's going to protect you when it comes to your communications with these potential investors. So to run a 506B, the question is, how do you get the word out? Again, we're going to focus on that. What we're doing for the substantive, for these two elements to satisfy them, is we're looking at SEC no action letters and enforcement actions. So it's evidence that proves that you already have that relationship with the investor, and that's what we're looking at here.
Can I interrupt you?
Yep.
Would this be then, like, let's say that you were in a Telegram group, you've been friends for a while, now you're going out on your own, and now you're going to be launching your project under the 506B. Would that, not that this is an actual legal situation, just kind of like a hypothetical,
Yes,
right?
yes.
But hypothetically, is that what you're looking for as far as substantial relationship, or does that need to go deeper into more of a business relationship and more of a formal relationship?
I feel like we played this out ahead of time because you're setting me up for these slides.
Oh my
It's
gosh,
awesome.
so sorry.
No, it's great.
Okay.
No, we worked on this together.
Totally did.
The substantive side, we're going to jump into that right now, and it's not just a friend on Telegram. So the substantive relationship, I'm just going to read this quote because it's easier. It would enable the issuer, that's the person raising the funds again, or a person acting on their behalf. So if you have a solicitor that you're working with, they have to be aware of the financial circumstances and the financial sophistication of the potential investor. And so that's going to be the relationship to prove that it exists and that it's substantial, or like there's enough duration of time with that relationship with the client. So the time that you've known them, even if it's online time, is good, but that's not enough for substantial. You also need to know kind of their financial sophistication, or their ability to be a accredited investor, let's say. So you have to have some sort of records or some sort of way of demonstrating that you know the investor's circumstances. This isn't just a check the box where literally people have websites you can check the box that says you're an accredited investor.
Okay.
That would not be substantive.
Okay.
But at the same time, it doesn't mean that the issuer has to have that relationship. If they have a solicitor that they're working with, or we'll get into kind of different groups that you promote at, like an angel group, the third party can do the due diligence on the investor. So, yeah.
That's really good. That's helpful. I think that a lot of these terms are word soup for the other side, and then for the enforcement side, a lot of the tech terms that blockchain and crypto use seem to be word soup, so if we could all get those words together.
Yeah, and substantive, I mean, these are, if you want to take this from the investor side, someone says they're doing a 506 raise, whether it's B or C, it doesn't matter. If they talk to you on Twitter and that's it, and then they're about to take your money, most likely they're not complying with the 506 regulations, right? So it's kind of a heads up that you want to dig a little deeper with these companies. The pre-existing relationship, so this is a kind of a time gap between when you meet the person and when you do the ask for the raise. The old rule of thumb is 30 days, but there's actually not a specific time frame for how long you need to wait. And then it's meeting people is kind of the most common way, but it's not the only way to consider a pre-existing relationship. Again, you can piggyback off of a solicitor's relationship with the person as well. So this again is one of those facts and circumstances situation, but just like you don't jump right into meeting someone getting married unless you're on TV. You're going to show a relationship before that, and so that's kind of where the pre-existing side comes in. So the idea of the pre-existing and the substantive relationships, those are to show that you're not, again, this is to prove this is not general solicitation, that you're just jumping out there and blasting it to everybody and hoping people come in. So that gets to kind of the number. So people say, well, if you can't do a general solicitation, your numbers are going to be smaller. And that's kind of true, kind of not. So some people in the industry, they suggested a limited number of offerees or a limited number of investors shows that it was a private offer, and that so that you can say, look, we didn't blast it to everyone because we don't have 1 million investors in this. While you can make that argument, that doesn't mean that the opposite is true. It doesn't mean that if you have a lot of investors that you were doing a general solicitation. It could still be a private offer. So just because you see a lot of investors into a token offering doesn't mean that you should be worried about it. Just see how your relationship builds with the actual issuers. So the idea being that if an issuer has done a raise in the past and they have those relationships with the investors from that past raise, they can bring them in, and then they can still do a private offering. They can have this group already kind of in a bullpen ready to go, and then they do the work to do private offering to get the word out to a couple more people legitimately. So that compounds or adds on to the group that they already had. So you can have a large number of investors, relatively large, and still be a private raise. So don't let the numbers throw you off necessarily. Yes. So after that, the question of the substantive and the sophisticated investors. So that's the status of the accredited investor. As we mentioned a minute ago, with the pre-existing relationship or the substantive side, that you need to know the sophistication level or the accredited status of the investors, and that can't just be a check the box. So people will do questionnaires, people will do research on these potential investors, people will use introductions through solicitors and brokers, so some sort of knowledge base that you know that they have the financial wherewithal and also the financial value in their accounts. They're to be considered an accredited investor. And there's some funkiness in this. So even if you're dealing with a solicitor, if they blast, say, a newsletter out to 2,000 accredited investors and they know they're accredited investors, that can still be deemed a general solicitation. So you just have to be careful about how that relationship is built. That's again on the pre-existing side. But the question on that is, okay, so you know they're accredited investors, right? So in theory, that newsletter should be fine. The distinction there is the pre-existing relationship. So do they know those? They know that those 2,000 are accredited, but do they know those 2,000? Or is it just a list of 2,000 accredited investors that they happen to blast out to? Yeah.
Now, is that covered under like an opt-in? If someone was going to do some sort of, I've seen other people do like an education seminar, and then at the end say, if you'd like to know more about the projects that I have in my office or whatnot, here's a card. You can fill this out. You can check this box if you want, and we'll send you more information. Or is that more? Does that not really satisfy that requirement? Would you say, generally speaking, obviously everything goes by facts of the case, and none of this is hard and fast at all.
Right. We're working with situational facts and circumstances. Right, is how we're building this whole thing out.
Exactly.
And that gets into yes, your question gets into the communication channels, right? So if someone has a presentation, and we'll get into presentations in just a second,
Okay.
and then you want more information, right?
Mm-hmm.
So that's kind of whether it's a card that you opt into, seeing platforms, a platform that has a bunch of raises, or if you want one specific company that you just heard about, that plays into the communication channels here.
I'm sorry,
So,
keep going ahead of you.
so again, we're going to look at no action letters to determine how to handle different platforms. So the online platforms that we're going to talk about, we'll start with the matching services. So these are matching the investor to the issuer. This would be a more high-tech version of what you were just talking about, where people give a card in to ask to see, say, a portfolio of different raises that are going on. So one of the no action letters, or a couple of the no action letters that have come about that talk about platforms that are okay. It's okay if it's a nonprofit that's affiliated with the issuer that's doing the platform, but otherwise the platform shouldn't be affiliated with the issuer on this side. You can't play favorites on the platform, so you can't pick one raise and put them at the top and then have to go back to find the rest of the raises, right? Unless it's a randomized raise that comes up every time, you can't have one raise over all the rest.
Can't like cherry pick, like,
No.
oh, this is kind of like the mortgage-backed securities, if you will, with the packaging, like,
Sure.
Oh, come with us and have your best one there, and then
Right. You can't, exactly. You don't want to just pick one and then have the rest in the background. That's not going to work. So then the platform itself can't investigate into the information of the presentation. They just have to put them up. The platform, can't make an assessment of the merits of the actual raise. And then the platform can't receive compensation outside of the administrative fees. They also don't have to necessarily, and again, check with your attorney if you're doing a platform, if you're creating the platform itself, but it doesn't have to do the investors can represent themselves as accredited investors on this side. The investor can't be affiliated with the issuer doing the raise, but they can be considered, they can act as an investor in the raises. That's fine. These are very strict circumstances we're talking about. They're very limiting. So if you think you fit 2 of the 3, that's not enough. Or 5 of 8, that's not going to do it for you. But then, as you were asking before about like pitch day contests and like going to match fairs and things like that. We could also start to tie in different conferences and when people have booths and they're trying to do that side. So the best example that we have is there was a university-sponsored symposium, and this was all the way back in '95. So this doesn't have to do with blockchain specifically, but you can create the analogies here. They had a symposium. It wasn't considered general solicitation because their mailing was targeted to accredited investors only. Now, as we talked about before, 2,000 accredited investors it still doesn't create that relationship, right? But they limited it to generic advertising. They didn't actually advertise any specific company that was going to be there for the raise. They just said, hey, come see it. And then otherwise, it was also word of mouth from prior attendees. There was no, the symposium itself, so the convention itself, didn't create any connections between the attendees and the companies, so doing the raise, so the issuers and the potential investors were not connected ahead of time, and no specifics of the financials of the raises were given in the presentations. So they talked about their company, but not about the raise. PPMs, private placement memorandums, were not distributed during the event. So, and there was no compensation to the conference holders, the symposium holders, other than the attendance fees. So attendees fees, excuse me. After that, it was on the investors and the issuers, the fundraisers, to make it happen after that. So you can look at that. Then a little more nuance would be a demo day. So this is where they host, companies come up and present, and then they, in theory, have investors watching these presentations, an audience. So it may not be general solicitation, even if the offers are mentioned. The attendance has to be limited, though, to issuers or organizers. And these have to be, the organizer of the demo day has to have that pre-existing relationship with the potential investors and the substantive relationship. So this mirrors demo days and angel investments. So as we talked about before, where solicitors, or where an issuer can rely on the solicitor's relationships to kind of have through association, you're doing the same with a demo day, and you're doing the same with if you go to an angel group and you present there. You're expecting them to have the pre-existing relationship with the investors, including the angel groups, and that they have done the vetting of the third parties. So that's everything on the private side. So we can be a little more, we can loosen up on our communications when we get to the Reg A+.
Can I go back?
Yes,
so sorry. For this last one, when we were talking about the 1995 symposium, and you gave a lot of details. Now, is that kind of like what, like different events that we would do, or things, as long as you're not endorsing a project, you're not asking for the raise for them, you're just offering them a way to speak, whether or not you have, whether or not you have a pre-existing relationship, right? So if it's members and we have people come in and see our members, obviously we have a pre-existing relationship with them.
With the people you're bringing in?
Right, with the people we're bringing in. But we're also not raising for them. We're not doing any of these other things that would seem to be, red flags. It would seem that it would fall under the symposium or the demo days, as far as we're not facilitating any investment.
So if you're bringing people in and you're just setting up just introducing people, without the pretense of, hey, you should invest in this group, then that's not going to, you're not soliciting for a raise, you're just introducing people. If you try, just because someone happens to have a raise going on, doesn't mean that that it's general solicitation.
Right.
If you're saying, hey, Jim, meet Mike, Mike has this company you might like, then Jim can meet Mike. Now, if you know Jim's looking to invest in companies and you know Mike's doing a raise, you can't play dumb and say, hey, Jim, meet Mike, and there's this raise going on. But at that point, if you have the knowledge that Jim has the money to invest, then you should, in theory, have that pre-existing and substantive relationship with the person you're introducing.
We're back. Going back to that, I think that's really helpful for a lot of people in the community, because a lot of people do events like that. And I think that is just something that everyone tries to be very careful of, because why wouldn't you be?
Yes. And that's not necessarily on the event host, right? If they have an event, they say, hey, everyone that wants to talk about your company, come in, and everyone wants to hear about your companies, come in. You're not, it's on the companies at that point to make sure they're complying with the Reg D raise, their private raise questions, right? And again, we're assuming that they're doing a private raise. We can get into the Reg A Plus next and do the more public side of things, the mini IPO side. And so if you're not focused on directly making those relationships, then it's not necessarily on you. It's not your responsibility at that point. So now
that's really helpful.
That's all. It feels so tight and restrict on what you can say. We get to the Reg A and it loosens up a lot, which is awesome. So Reg A, the first part is the communications you do before you're filing and after you're filing for the raise follow the same restrictions, which are a lot looser. You're allowed to use solicitation materials before and after the filing. But you're subject to the same compliance rules before and after. So you can advertise everywhere you want, anywhere and everywhere you want, social media, radio, things like that. However, if you're doing the test the water, and that's before you file, what the intent of those advertisements is to, as the name says, test the water, make sure that there looks like there's enough interest in your raise to actually go through the process of a Reg A plus, because the Reg A plus is going to be a lot more expensive on the legal, the accounting, and the print side to do a Reg A plus. That's why they're saying go ahead and do the pre-advertisement, see if people want to even invest in what you have. Now you can't bind people. These advertisements can't be binding on the potential investor. That's something that's important to point out. You're also still responsible for making materially true comments. So you're still liable for false or misleading information. And what can happen there is then you're also opening yourself up to liability, to lawsuits for misrepresenting in any way.
I'm so sorry. Would you say that the FTC is going to become a lot bigger player in some of these companies as far as UDAP goes? Very deceptive.
So it's interesting. So we just had Block Congress just had their event where I was on a panel with the FTC gentleman, and he was great. They are going to use the same standards for any token as any other company that makes a material representation or tries to raise money or deals with the public in any way. They're going to protect the public, and part of that is they're going to look at what information was sent is being presented about the raise. So yes, they probably will get involved when people are making extreme claims that they can't hold up as true. Part of that would be, let's see, they are going to make these investigations or conduct these investigations, but they're not necessarily the ones that are going to be looking out for or actively pursuing, right? They get hints from the Better Business Bureau. Oh, yeah. They get hints from other regulatory bodies. They get hints from disgruntled investors / customers. So you make someone mad and they think they have a bunch of material that you make these big promises you're not going to be able to keep. They can send that to the FTC, and then the FTC can start doing their investigation if they want. So while they might not, might not actually actively check every single website blockchain company, they'll get hints, and then they will do their job.
And yeah, that's what I was wondering more so is this going to be a catch-all? Because the way I read that, part of that, one of the guidance documents that came out recently was more like, it mentioned the FTC, and it was like, well, maybe a scam company could do absolutely everything perfectly right as far as the SEC goes, right? Despite the fact that they're not shipping the product, and then those claims become important, and then that leads to, we can't, I don't know.
Yeah. It could lead you open to more regulators than just one coming after you at that point. So, that's the test the water side. So,
what would you file with a test the waters? Is that a specific regulation?
So you're filing under Reg A plus. Now, when you're doing the test the water part, you don't need to file it just yet. It's when you start doing the Reg A plus, the raise itself. That's when you're going to need to file. But you will need to include all the material you did in test the water, and it does need to comply with the Reg A plus regulations. So while the SEC won't preview or pre-qualify the advertising in any way, so you can't send it to them early and say we're going to file later on. That's not going to work. You do want to be careful about what you say, because you're still subject to it's anti-fraud and then civil liability as well. So again,
does that also fall under FinHub and asking for, and FinHub was offering to have meetings with people if they gave all of their information?
That's different. That's more of just a company having a conversation with the SEC and just trying to get a feed on what's going on there. From what they started getting flooded with information, so I wouldn't rely on getting fast feedback, especially if you're just throwing out a couple lines and saying, are these lines okay?
Right.
That's not their job. They're going to tell you to go to an attorney to help you with that side of things. Because if they had to play attorney to every company that was out there, they're busy enough, right?
Yes.
So, but with these public promotions, you have to know who counts as a promoter. This is something that there are people, just because they're not an employee, you might still be responsible for their promotions, and that's important to know. So promoters can be people that receive a benefit from the issuer. So a lot what we see is airdrops, right? People think that they're great and they have a use, but you have to be careful because all of a sudden when you're giving someone a benefit, you could be creating a relationship. And we use the term benefit loosely, and the benefit given to the promoter, the person doing the actions for you, those actions that they take, also loosely defined, are a benefit to the company. So there are cases where just providing contact information was considered a benefit to the company. So just have to be careful there. Which gets into what is your responsibility. And this is not just for the issuer trying to raise money. This is for the people that are working with the company or fans of the company, right? You want to know what your rights are, what could happen. One of those. Someone made a good point. They said, "Hey, remember those free airdrop tokens I gave you? Well, now they're worth something, so you have to pay taxes, right?" So there are responsibilities on both sides.
Tax bill for you.
Yeah, exactly, and you don't want to get surprised with that. What are the issuer's responsibilities when they have promoters? Whether it's just giving them a free benefit, giving them a benefit that you consider free, being the airdrop, or whether you actually hire them on. So some of the things you have to look out for are, do these people make promises or guarantees that you can't keep? We've seen people out there saying, hey, you should buy these tokens because they're going to double in value. Not even talking about the security side of things, but you're making a promise, right? Something that just a promise or something that can be considered false or misleading. So you want to be really careful there. And then when someone can be looked at or viewed as an employee or someone with power within the company, even just on the outward communication side of things. So think of your Telegram channel moderators.
Mm-hmm.
They could accidentally lock you into a contract. So that's something that you don't want to have happen, a verbal contract even, something that could really put your company in a bad spot. They could also, when you're working with a promoter or, I use the word promoter pretty loosely here, but anyone that's doing communications for your company, if you're like, hey, this is great, they're promoting this stuff, we want to psych them up on some new stuff we have coming out. If they spill the beans early, and you had a confidentiality agreement with other parties, you could lose that confidentiality right because all of a sudden it's public knowledge. So you just want to be careful there. You want to make sure they're not selling anything for you.
So just backing up, whatever is said on social media, in whatever channel, despite how private it is, would you say that is counted as that is now public information?
It's out there, right? Yes. Yeah.
Because there's that argument that basically there's no social media that's private, right? Because as far as Telegram groups go, even DMs are intercepted and things like that on Twitter. Twitter groups, you might have pseudonyms that you don't, that have joined, or people that have swapped accounts, things like that.
Yeah, I guess it depends on how extreme you want to take that. So a private DM between two people is kind of
between more people than just,
you're gonna have to be careful who's on there. Treat a DM as an email, right? So if a DM has two of my employees on there and they both are tied to this company, they're employees, so they're tied to a confidentiality agreement, we hope, then you're expecting those two to keep it private. That doesn't make it public, even though in theory they could email that out to everyone else. That's the action that's gonna cause trouble, is when that person forwards that on further along. So that's more take that more into like a business sense of if you give it to someone, you want to trust them that they're not going to send it out to everybody, screenshot it, send it out, whatever it is. But that is more like a human vulnerability, like in cybersecurity when they say it's a human issue there. That's not necessarily that the company was doing anything wrong. It's more the spreading the news to someone you trust, but you don't have locked into an NDA, that all of a sudden they spread the news, not maliciously. They got so excited, they blurted something out, or they went to a meetup and had an open bar and they blurted something out. That sort of thing is what you're trying to prevent. But along with those responsibilities, the reason that this is, or the big part about this is, even if they talk about the raise, all these raises have disclosures, disclosure requirements, right? Which is why picking up investors or making promises to investors, potential investors on Twitter is not a good idea. There's no way you can fit the disclosures you need into a tweet, along with whatever else you want to say. So the same holds true to Telegram groups, to social media in general. And this is actually, it's not a blockchain specific issue. There were a couple of examples that were fun examples I like. Netflix, for one. So Netflix, their CEO created a fake account. This is a past CEO, created a fake account for different rating companies, rating agencies like Yelp, started talking about how great Netflix is. So they stopped him on this. They said, "Hey, these are fake accounts."
These are fake reviews.
And they said, what about the disclosures? You're a CEO, so you have extra responsibilities on what you're allowed to disclose and what you're not allowed to disclose. But he also pointed out that he didn't disclose any confidential information or anything that would influence the price of their shares. So that one just dropped off, just disappeared.
That's interesting.
But that was a fun one. The more recent one, and it was recent and now it's been re-upped again, is, and I'm a big fan of him, but still, Elon Musk with Tesla. So when he made the comments about having investors to buy everything back private, that information shocked the market in a way that the SEC, they're still going through this with him, but they had an issue with that, saying that, look, you disclose information you shouldn't have, that you need to report first, in a public channel being, if I remember correctly, it was a podcast, but it was something or his Twitter account. But either way,
it's the 420. Right?
It was Twitter, yeah. So that was not ideal. So then he made an agreement again. The SEC and Elon through Tesla had agreed that any tweets that had material information needed to be cleared by Tesla's attorney first. A Twitter sitter. I like that. Their attorney. So then he made another comment just recently that that could or could not be construed as material information, and they had to go back to court. And Tesla argued that, or Elon argued that it was not clear whether this was material or not. The directions that the SEC gave him about what needed to be cleared through an attorney was also not clear directions. The judge kind of agreed with that, but anyways, they're rehashing this. So having people in your C-suite, it's very, very important that they know what they're saying in public, in social media accounts, because that can get you in trouble or draw regulatory attention.
Well, what's really interesting is there are entire services, like I talk to people in blockchain and crypto about this all the time, and no, it's social media, no one's going to find it, it doesn't matter what I said. But they're actually like full legal litigation services that will go through and can parse all social media and things and do this very well as far as e-discovery goes.
Oh, absolutely. I mean, we use that ourselves for our investor side. Is one people say that the internet's forever, right? And there are ways to, even if things are deleted, you can go back and find the deleted post. So no, don't rely on the signal from the noise issue where you say, oh, there's so much noise that they'll never find these little issues. You can keyword search and you can really filter down in what you need. So no, that's not a good excuse.
And there are services that specialize in this, and they are like really top of the line services, like from, I don't know.
Oh yeah, absolutely. And
so,
I mean, they're getting paid and they're doing a good job at finding what they need to find. And this again, this goes back to it's not just employees that you have to watch what they're saying, but other people are making promises for your company. You can't. The argument that we don't control them, it doesn't fly. If you know about it and you're the company during the raise, then you need to fix that. You need to either talk to the author of the post or the article and correct it. You can't just like ignorance of the law doesn't protect you. You can't say, I didn't know that was a rule. You can't say, oh, we didn't write that. If you know about it, you need to correct it. So,
Right.
This, again, falls under disclosures. It's an issue for misleading statements, false statements. You just want to just control what's set out there. It doesn't mean that you can't talk about your company. You should be able to talk about your company. You should be able to say what's true, right? And just make sure that everything being said is very true. A good example of this is if you want to look to Theranos, and they hired a large ad agency that said, okay, here are our marketing materials that we want to put out there. These are the statements you told us. Now you have to show us that these statements are true, so that we can actually use these ads.
Right.
And that's when things fell apart
Right.
for them. So
Yes.
yes. So check out the best interview I've seen. Let's say is the ABC Dateline Bad Blood, or excuse me, the Drop Off. They talk to the ad company, and they give some great examples there.
The drop off, it's called?
Yes.
Oh, that sounds really cool.
So
Are there sources so for people in the cryptoverse or in the blockchain community that, whether they're closely affiliated or not closely affiliated, they're loosely affiliated, or they're doing some freelancing work for these people, that there is some site that you would say to go to offer just a simple disclosure, like this is, these are my own personal views, I'm not.
Oh, okay. So if you are working, even if you're affiliated with them in any way, it's that's whose voice is there, right? That's important. Whose voice is online or being and that's we go back to the Netflix example.
Right.
Whose voice is it? Even though people didn't necessarily know it was the CEO, that was the CEO's voice. Where the opposite is also true. It could be some random person, but if they're appearing as a authority figure for the company, even if it's just loosely affiliated marketing for them, the issuer needs to pay attention to that and needs to get ahead of it. It's just so if you're looking for information on that, I would say the best move is for the startups the issuer, the person raising the money, to have a handbook. It doesn't need to be 20 million pages. It just needs to be guidelines on, okay, if you have, and check with your attorney first on what this works.
Wonderful, wouldn't it?
Yes.
Put out by either one of the communities within Chicago or something, just guidelines about maybe best practices.
Absolutely.
Not like this is legal binding things, but just giving people a way to navigate through the FUD would be helpful.
Yeah. And that, with that, it's just the guidelines you put out there that says, look, if you're making a statement, here's the link we want you to tie to the end of this as a footnote that gets to more disclosures or something. You need to show a real effort to getting your full disclosure out there for any potential investors or not investors, but just people you're making promises to.
True, and even it goes to privacy policies too. I've seen many companies that don't have a privacy policy statement, and with all of the debate on privacy, cybersecurity, data breach, and everything, it's just so important to always have a privacy policy. I know there's some sites that will do like a canned version.
Yes. Where
you can obviously have a lawyer write one for you. That's, that would be optimal. But just have something, because
even if it's plain English, at least get something started.
Right.
And then if you start to get traction in your startup, then get serious about it. Obviously, I would say get serious from day one, but be realistic as well.
Right, and that ops aren't like a second-class citizen. They're like actually there to help you.
Yes.
Operations.
Yes.
This is awesome. Okay. Sorry, I got you off topic.
No, that was, I think we flew through, but that was
Sweet. Well, this has been so helpful. I'm going to write up just a little article about everything we talked about, and your slides were okay.
sorry. No. This is just our fine print.
Okay.
Just remember that what we were talking about today is not. It's talking about the law, but it's not your legal. Your individual
Chris
legal
is not
advice.
your lawyer, and so.
And as we talked about, these no action letters, these enforcement actions are all based off of facts, specific facts. So you can, even if it looks similar, it might not be perfect to your situation. So go ask an attorney you like for help.
And we do like Chris because he's one of our members. He's been very helpful to us, and just giving education for a lot of the companies in crypto and blockchain. You've been in crypto and blockchain for a while now.
We're getting old.
I know, right? Because now we're like the older people in it. But there's a great thread on Twitter. You know what I'm talking about when we were talking about the statements that we've heard in different companies. So, like, don't be that guy. Don't be the guy that gives your lawyer the $20,000 bill that after you said that you're going to pay in tokens. Oh, yeah, now there was something. Or, no, I'm decentralized. So the law doesn't apply to me because, as we know,
they will. They'll find an authority group. The authority over what's running, whether it's purposely put together or loosely tied. They'll make that connection.
Exactly.
Don't just because you see a blog post from a lawyer, don't take that as your legal opinion letter. Those two things are separate documents.
Yes, a legal opinion letter does not come in Telegram usually.
No.
Maybe it does in some ways, but I don't think I've ever seen a legitimate one. So
I have to question that lawyer.
Exactly. And the biggest thing, I think the biggest takeaway we could say here is to do your own due diligence, make sure that you're investigating, the company that you're affiliated with loosely, tightly, however you say that, and that you're making smart choices. Because these choices, what we've talked about and why we wanted to do this series is that these have actual long implications. If let's say you do something very bad but you didn't know it was very bad, no one's going to really care that you didn't really know it was very bad. And that could cause you to be labeled as a bad actor or limit different things in the future.
And if you're labeled a bad actor, then forget being in any startup from then on, trying to raise money. It's not going to happen.
Exactly. And so we just want to educate as many people as we can about the right way to do things. And obviously the right way to do things is honestly to consult an attorney that you like. And how can they reach you if they want more questions or more?
Yeah, if they have questions for us, it's convexlegal.com or Chris at convexlegal, convexlegal.com. And feel free to send us questions. We'd love to help out as much as possible.
Awesome. And then you said Elaine is at the Chicago Bar Association. What's on the agenda next for you guys?
So let's see. She's speaking today on the different market structures and the challenges that are still out there, or the perceived challenges. So, for example, custody and insurance. While people perceive it as a challenge and they say they need service, that there aren't any services out there, there really are. She's covering the ones that are out there now and what they look like, how they're evolving. So that's what she's focused on today. And then we have, we will have a couple of custody-focused companies coming into Chicago and speaking about their solutions, but the date's to be determined. So, yeah.
Excellent. All right. Well, thank you so much for tuning in, and I'm sorry that it dropped at some point. We're not sure when. But if you have any questions, you can DM us, and you can also DM Chris at
34 Act.
There we go. All right. Have a good day.
Bye. Thanks.
Bye.